Hi, Mr. H. This is part 2 of the Etelvina Betty, the Piovanetti rent overcharge case. Okay, so this week papers were filed in landlord-tenant court. Now, I'm staying with a very nice Jehovah's Witness who is engaged in a landlord-tenant action right now, and her attorney, the attorneys for the big bad landlord, this is the Orthodox Jewish landlord who goes to Israel, his attorneys filed papers in landlord-tenant court a couple days ago. We're asking to see those motion papers. Those papers are motions to dismiss. I stopped by Betty's attorney's office yesterday, and I got a quick look at the motion papers, and he's having this big knockdown drag out war. He won't let me see the motion papers. Why? I don't know, but a quick glance at them and I saw at least 2 lies. So I'm going to present one of those lies here because it's really easy to understand in just a few minutes. 3 or 4 sentences on 3 documents. Now, here's the deal. When the other side presents a motion, when you move, you're asking the judge to do something. When the other side presents a motion, and that motion contains false statements of material fact, outright lies, you do not continue to present the merits of your case. What you do is you say, in this motion, there are false statements of material fact. These are lies. I want this case dismissed immediately with prejudice for my client, Mrs. Piovanetti. I want attorney's fees. I want her to get triple damages for the rent overcharge, which, by the way, we already proved. Now the only thing we're arguing about is whether the overcharge was willful, so we can get treble damages. So basically, when the other side lies, you do not continue to argue the merits of your case. You point out their lies, you go to the judge, and you say, I want this action dismissed with prejudice because the other side lied, okay? It's very simple to understand. Now, I'm going to point out one lie. Here comes example 1. This is Betty's lease, okay? This lease is good for from October 1st, 2010 to September 30th, 2012. So this is her current lease. This is the rider to her lease. And what this lease says is that there's a provision in here that requires the tenant to pay the landlord's attorney's fees. So I'm at Betty's attorney's office yesterday, and I'm looking through this motion, and the lie that Betty's landlord and his attorneys told in that motion was, oh, there's no provision in the lease for attorney's fees for the tenant. That's a lie. So, and I'm going to take you through this to show you. So the first thing we're going to do is change the camera view to go look at Betty's lease. And I'm going to read this to you, okay? So this is Betty's lease. This is the current lease. I'm going to increase the magnification. And we're all going to read together. Let me drop this down just a bit. Okay. This is Betty's lease right here, apartment 16 Ocean Avenue. It's not like it's any secret, right? Okay, apartment 16 Ocean Avenue. This is the rider to the lease. And we're going to go to paragraph or item number 37. And I'm going to read this to you, okay? Let me make this a little bit bigger. Now, I'm going to drop it down a little. Okay, now I'm going to read this to you. Now, the lie that was told in the motion that we have to respond to is that the lease does not provide for attorney's fees. That's an outright lie. The landlord and his attorneys know that's a lie, and here's the lease. This is item 37, and I'm going to read it right here, okay? In case the landlord has reason to start a dispossess proceeding against you, the tenant, then the tenant shall be required to pay the landlord reasonable legal fees, which during the term of this lease shall be considered to be $75 for a 3-day notice, and $150 for petition unless a larger amount is awarded by the court. Okay, so what we've looked at is Betty's lease that says if she loses against the landlord, she has to pay his fees. So, and this is exactly what we were talking about in Jersey, which I'll get to. Now, we're going to look at New York State law, real property law, that says, hey, if you got a lease, right here, if you have a lease, and your lease says that you as the tenant, if you lose against your landlord, you have to pay your landlord's attorney's fees, then it's implied. It's a fundamental principle of contract law, a fundamental fairness, to say that it's implied that if you defend successfully and you, the tenant, win, then your landlord has to pay your attorney's fees. Okay? It's not rocket science. You don't make up a lease, which is a contract that says all the power is to the landlord and you, the little tenant, get screwed. Okay? That's not what's going on here. The playing field is level, so that if you, the tenant, win against your landlord, you can ask him to pay your attorney's fees. Okay, it's implied. This is the fundamental principle of contract law. It's considered the principle of unconscionability. You do not have to have a New York State law that says this, but guess what? We do. So let's look at New York State law that says if you got a lease, like Betty has a lease, and this lease says that if you're the tenant and you lose against your landlord, you have to pay your landlord's attorney's fees, then the same principle of reciprocity and fairness apply to you. If you win against the landlord, you can make a counterclaim for your attorney's fees. Okay? So let's look at real property law. This is New York State real property law right here. And this is section 234. Let me increase the magnification so we could all see it. Okay? And I'm going to read it to you. Let me expand this a little bit. Okay. This is the tenants. This is real property law in New York State, section 234. Right here, section 234, the tenant's right to recover attorney's fees in actions or summary proceedings arising out of leases of residential property. Okay, this is not rocket science. It's really simple. And the sections that I've highlighted, I'm going to talk you through this in real English, not this legalese stuff. Okay, so right here, basically it says, and I'm going to read you through it. I'm going to give you the gestalt and then we'll read through it. Whenever there's a lease of residential property, okay, so you're a resident, you got a lease, that lease says that the landlord may recover attorney's fees, then, let me increase the magnification a little bit so you can see it. So I'm going to talk you through this like in real language, not in the bureaucratic legalese stuff, okay? So basically it's very simple. Whenever a lease of residential property shall provide that in any action or summary proceeding just means, you're going to court to get something over with quick, the landlord may recover attorney's fees or expenses because the tenant didn't do something they were supposed to do, or the amounts paid, blah, there shall be implied. Okay, so if you've got a lease and you're going into any action or summary proceeding, it's just you're going to court, and the tenant didn't do something they were supposed to do that was agreed in the lease, then there shall be implied, even though it's not explicitly stated, there shall be implied. There you go. There shall be implied in such lease a covenant by the landlord to pay the tenant the reasonable attorney's fees and or expenses incurred by the tenant as a result of the failure of the landlord to perform any covenant agreement, blah, blah, blah. So the landlord does something bad, or in the successful defense of any action or summary proceeding commenced by the landlord against the tenant. So, if if you're a tenant like Betty and you have a successful defense of any action or summary proceeding, same thing, a summary proceeding is just something that's a court action that's happening quickly, commenced by the landlord, like the landlord in Betty's case, against the tenant, and it comes out of the lease, then you too can get attorney's fees too. So it's implied. There's the principle of reciprocity. If you've got a lease, I'm going to read you this whole legalese thing, and then I'll break it down into simple language, okay? So this is tenants' rights to recover attorney's fees in actions or summary proceedings arising out of leases of residential property, okay? This is the tenant's rights. A summary proceeding just means it's something that's happening quickly. Your landlord is taking you to court. It's not going to be a long, dragged-out thing. It's a summary proceeding. We want to get it over with quickly. So whenever a lease of residential property, oh, big deal, you're a resident, you got a lease. The lease shall provide, the lease says, that in any action or summary proceeding, there's a court action, the landlord may recover attorney's fees and expenses incurred as a result of the failure of the tenant to perform any covenant or agreement contained in the lease. So if you're a landlord and your tenant does something bad, you can take your tenant to court and you can get attorney's fees in addition to whatever compensation there is for whatever bad thing your tenant did. Or that amounts paid by the landlord therefore shall be paid by the tenant as additional rent. That phrase just means that instead of going after you for, attorney's fees, he's just going to tack it on your bill as additional rent. So whenever a lease of residential property shall provide that in any action or summary proceeding, the landlord may recover attorney's fees and or expenses incurred as a result of the failure of the tenant to perform any covenant or agreement contained in the lease, or the landlord says that any amounts paid by the landlord shall be paid by the tenant as additional rent, here comes the tenant's rights part, there shall be implied in such a lease a covenant, an agreement by the landlord to pay the tenant the reasonable attorney's fees and or expenses incurred by the tenant as the result of the failure of the landlord to do anything he was supposed to do, to perform any covenant or agreement on its part to be performed under the lease, or there shall be implied in such a lease that the landlord should pay the tenant the tenant's reasonable attorney's fees, or in the successful defense of any action or summary proceeding commenced by the landlord against the tenant arising out of the lease. Blah, blah, blah. What else do you need to know? And an agreement that such fees and expenses may be recovered as provided by law in an action commenced against the landlord. So if you're a tenant and you win a successful defense against your landlord, you can ask for reasonable attorney's fees. You can get it in an action commenced against the landlord, or to make it even easier, or by way of a counterclaim in any action or summary proceeding commenced by the landlord against the tenant. So, whereas here the landlord has taken the tenant to court and the tenant successfully defends, the tenant can ask for a counterclaim where the tenant can collect reasonable attorney's fees. Okay, this is not rocket science. It's very simple to understand, okay? The landlord takes you to court, the landlord wins, you pay his attorney's fees. The landlord takes you to court, you, the tenant, win, you get to ask the landlord to pay your attorney's fees, because that's the principle of reciprocity. It's implied, it's a fundamental principle of contract law that we do not draft these inherently unfair contracts so that one party, the landlord, has all the power and you, the piddly little tenant, has none of the power, so you can be squashed like a bug. Okay, we don't do that. That's not what the legal system is about. Okay, so you can imagine all kinds of scenarios where there's a greater, a party with more power and a party with weaker power. Let me give you an example. A great, big, bad, racist university like Yeshiva University, which has a lot of power and a lot of connections and a lot of money, can go against a poor little student like me and ask the poor little student to sign a contract to release the great, big, bad school from liability, or the great, big, bad school is going to expel the poor little student, as would happen to me. I refused to sign a contract when I was in medical school, releasing my big bad school from liability, because it violated the principles of unconscionability, basic contract law. I can give you more examples of the great big industry that would have its laborers sign labor agreements that would squash them like a bug. That's why labor fights back. Okay, I can give you lots of examples, but basically here's one. Okay, we don't put all the power in the hands of the great big bad landlord to squash his little tenant like a bug. Okay, that's the basic principles of contract law, and in New York, we've turned it into a law. Okay, very simple to understand. And why is this important? Because this is the law that I would like to have passed in Jersey. So, as long as we're here, here's a little element for the Jersey boys. Now, I was fighting this fight in Jersey. And I'm winning against my big bad landlords and the dishonest attorney that they hired. And we're going into a frivolous eviction. This is like frivolous eviction number 4 during January, February, March, April, May of 2008. My landlords presented me with a proposed lease. The lease was not fair to me. I got Lawrence Sidoni at Northeast New Jersey Legal Services, this is legal aid, to defend me in this action. And as we go through this, I say to Judge Fast, this isn't fair. My landlords are presenting me with a lease that says if I do bad, I have to pay their attorney's fees. I want the same consideration. That's fair to me. And since Jersey had no law, like New York law I just showed you, I said, Judge Fast, since I can't cite to Jersey law, because there's no law that gives this to tenants in Jersey, I could have also argued the principles of unconscionability in basic contract law, and should have, but since Jersey has no law like New York law that I just showed you, I can cite to the nearest state. So I can cite to the nearest state, which is New York, and put in New York law in my submissions to Judge Fast during late summer, early fall of 2008. And in fact, I gave that New York statute to Lawrence Sidoni and said, please give this to Judge Fast. And guess what he did? He omitted it deliberately so Judge Fast could rule against me, and here's what Judge Fast said. Okay, this is page 6 of Judge Fast's ruling, and here's what Judge Fast said. And here's how Lawrence Sidoni, my attorney from Northeast New Jersey Legal Services, stabbed me in the back. And here's what he said. The defendant cited, I want to make this bigger. Just one second. Here we go. Defendant, that would be me, cited no authority to support the obligation of a landlord to reimburse a tenant even when the tenant is successful in defending an eviction or conceivably another form of case. Right here, defendant cited no authority. Right there, okay? There was authority. All Lawrence Sidoni had to do was cite to New York law, as I've just shown you. And I gave New York law, that piece of paper, to Lawrence Sidoni, and I asked him to submit it and make the argument to Judge Fast that it's not fair in a lease that the landlord gets his attorney's fees paid, but I can't get mine when I'm successful in defending against the landlord. So right now in New Jersey, we're fighting to get this new law passed because it's fair to both sides. And this is how Lawrence Sidoni at Northeast New Jersey Legal Services deliberately, maliciously, intentionally, with criminal intent, omitted a document so that making a big hole in my case so Judge Fast could rule against me. And there's one other note I want you to take on this. And even though it says defendant cited no authority to support the obligation of a landlord to reimburse the tenant, even when the tenant is successful in defending an eviction, or conceivably other form of case. And he makes a footnote here. This is footnote 11. And if you go down to footnote 11, what you'll see is the rules of the court may provide relief to a successful tenant in certain circumstances, but that is not the issue in this case, okay? So what you got here is defendant cited no authority, okay? There are a number of different ways that Lawrence Sidoni could have gotten me reasonable attorney's fees. He could have said this was frivolous, this contract violates the principles, the basic principles of contract law, and after all, the lease is just a contract. There's a basic fairness issue here. He could have also cited to New York law, which is time-tested. There was a lot Lawrence Sidoni could have done. But Lawrence Sidoni's job was to lose my case. So he deliberately, maliciously, intentionally, with criminal intent, lost my case in early September of 2008. Had Lawrence Sidoni put that statute in there, 2008, 2009, 2010, 2011, 2012. Okay, that's 5 years of protection that the tenants in New Jersey could have had, but it was more important to hurt me as an individual than to give protection to every tenant in the state of New Jersey. And who was waiting for this? Real estate agents who are going to start driving positive, progressive change on the grassroots level. I had real estate agents who, when they're hired by tenants, would have cited to my case and would have said, we need to put this clause in your lease. You're the tenant. The landlords always have this because it's called boilerplated. We always protect the landlords, but we never explicitly protect the tenants. Now, in places like Newark, where I got the support of 3 of the largest tenants associations in Newark, tenants make up 75% of the population. So those are votes out there, ladies and gentlemen. So we always protect the landlords, but we never protect the tenant. That's not fair. And this is the new law that we're fighting for in New Jersey. So what else do you need to know? I think that's about it. I haven't seen the rest of Betty's motion, but I can tell you this. There's another lie that I saw in there, and I'm going to make another brief video about that lie. And what I can do is contact the judge directly and say, there's something really wrong that's going on in Betty's case because her attorney will not let us see the court papers. Now, I can go down to the court and look at them, so what's the big deal here, okay? The lease does provide for attorney's fees. The lease provides for attorney's fees for the landlord. New York law gives the same consideration to the tenant. So when the landlord's attorneys against Mrs. Piovanetti claimed in their most recent motion to dismiss that the lease does not provide for attorney's fees, they lied. So her attorney should not be fighting me and Mrs. Piovanetti. What he should be saying is, the other side lied, Judge. And when the other side lies, I move for this case to be dismissed with prejudice in my client's favor, in Mrs. Piovanetti's favor. I want attorney's fees, and I want triple damages for the rent overcharge, which we have already proven, and now we're only arguing to show that it's willful so that Mrs. Piovanetti can get treble damages. And I've shown how every tenant in the state of New Jersey was left without protection over the last 5 years because Lawrence Sidoni, Northeast New Jersey Legal Services, made it more important to hurt Lydia Radin as an individual than to protect every tenant in the state of New Jersey.